Good evening. I'm Marcy Kahn, Chair of the New York City Bar Association Rule of Law Task Force, and I welcome you to the second session in our series on New Frontiers in Federalism, a four-part series this spring. This series is intended to take a hard look at how recent Supreme Court decisions like Dobbs, Bruin, and West Virginia versus EPA, as well as state legislative changes, are changing and challenging our understanding of federalism in terms of relations among the states and between the states and the federal government. During these sessions, we bring together national thought leaders to probe the new federalism environment for judicial, legislative, and administrative agency action through discussion of the issues of corporate conduct, reproductive rights, climate change mitigation, regulation, and gun safety legislation, and ponder the future of nationwide responses to these issues bearing so closely on the lives of ordinary Americans. Our program this evening is entitled Interstate and Regulatory Clashes, Commerce, Corporate Conduct, and the Corporate Law. We have a stellar group of speakers to address us this evening who will bring perspectives from the judiciary, private practice, and academia on critical questions raising federalism issues in the commercial arena today. These include how most effectively to police money laundering and insider trading, as well as an examination of current trends in environmental, social, and governance standards. Where are the gaps in enforcement and regulation? And should they be filled at the federal or state level? And to what extent can they be filled most effectively by legislation, judicial rulings, and/or administrative regulation? I offer the thanks of the Rule of Law Task Force to the Birnbaum Women's Leadership Network at NYU Law School and the Brennan Center for Justice, also at NYU Law School, for co-sponsorship tonight, as well as to the 6 other city bar committees who we have appreciated having as our co-sponsors for this series. And my thanks to our series program chair, Robert Cusimano, for conceiving this timely series of programs, to Jennifer Rogers, our chair, and to Stephen Cass, all of them members of our planning team, for their considerable work in putting this series together. Before we get underway, I want to explain the format for tonight's virtual discussion on Zoom. All members of the audience will be muted during the program. The Zoom chat function will be disabled for audience members, but you can type your questions into the Q&A function by clicking the tab at the bottom of your screen. We will try to get to as many of your questions as time permits. Our moderator for this evening's program is Stephen Cass, Senior Environmental Counsel at Carter Ledyard in Milburn, and immediate past chair of City Bar's Task Force on the Rule of Law, and member of the planning team for New Frontiers in Federalism. Steve will be introducing our speakers, all of whom will be glad to take questions at the conclusion of the presentation. Steve, the floor is yours.
Thank you, Marcy. In 1932, a young professor at Columbia Law School named Adolph A. Burley published a study on the modern corporation and private property, which many of you may recall from your earlier studies. In his conclusions, Professor Burley noted the extraordinary degree to which shareholder entrepreneurs had ceded management of American corporations to directors and controlling individuals who were not shareholders. By doing so, Burley wrote, they have placed the community in a position to demand that the modern corporation serve not alone the owners or the control, but all society. This, he wrote, offers a wholly new concept of corporate activity. Neither the claims of passive ownership nor those of controlling management can stand against the paramount interests of the community. When a convincing system of community obligations is worked out and is generally accepted, in that moment, the passive property right of today must yield before the larger interests of society. Should the corporate leaders, for example, set forth a program comprising fair wages, security to employees, reasonable service to their public, and stabilization of business, all of which would divert a portion of profits from the owners of passive property, and should the community generally accept such a scheme as a logical and humane solution of industrial difficulties, the interests of passive property owners would then have to give way. Courts would almost of necessity be forced to recognize the result, justifying it by whatever of the many legal theories they might choose. It is conceivable, indeed, it is almost essential if the corporate system is to survive, that the control of the great corporations should develop into a purely neutral technocracy, balancing a variety of claims by various groups in the community and assigning to each a portion of the income stream on the basis of public policy rather than private cupidity. Now, Professor Burley was no socialist, but a hard-boiled Roosevelt brain truster trying to save capitalism at a time when economic realities had outgrown the historic assumptions of corporate law. His questions remain strikingly relevant today as our nation grapples with the extent to which large corporations and their management should be accountable to the community at large, not only with respect to fair wages and consumer products, but also our global environment, human rights, and our democratic institutions. We are fortunate this evening to have three expert grapplers to help us consider Professor Burley's questions, and to do so not in the abstract, but in the context of our nation's global economy and the federal system through which we seek to regulate corporate conduct. Our keynote speaker this evening is United States District Judge Jed Rakoff. Judge Rakoff, a senior judge in the Southern District of New York, is a graduate of Swarthmore College, Oxford University, and Harvard Law School. He is universally recognized as one of our nation's leading district court judges and one of the very best judges for whom to clerk. He has served for many years as an adjunct professor at both Columbia and NYU law schools. He has traveled widely on behalf of this bar association to protect judicial independence in nations around the world, and has, in addition to his many notable opinions, written extensively about the need to improve our judicial system. We are honored to have him as our keynote speaker for this program. After Judge Rakoff's remarks, we will turn to our two exceptional panelists, Brad Karp and Michael Posner. Brad Karp is one of the truly exemplary lawyers in our city and in our nation. A graduate of Union College and Harvard Law School, Mr. Karp has been the chairman of the Paul Weiss firm since 2008 and is widely recognized as both an outstanding litigator and corporate counselor. He has served in leadership roles for more nonprofit organizations, including this bar association, than I can begin to list. Yeah, he has received dozens of public service awards and has most recently championed the role of pro bono counsel in meeting the needs of our nation's immigrants and in protecting our citizens' voting rights. We're also extremely fortunate to have Professor Michael Posner on our program. Professor Posner graduated from the University of Michigan and UC Berkeley Law School, is the director of the Center for Business and Human Rights at NYU Stern School of Business. He served from 2009 to 2013 as Assistant Secretary of State for Democracy, Human Rights, and Labor, and before that, as the founding executive director and president of Human Rights First. Professor Posner writes regularly on challenges to corporations confronting human rights abuses at home and abroad, and played a pivotal role in helping this bar association launch its own human rights investigations in Latin America and elsewhere. After Mr. Karp and Professor Posner have commented on Judge Rakoff's remarks, we will give Judge Rakoff a brief rebuttal opportunity if he wishes, after which we will open the virtual floor for questions to all of our speakers. Judge Rakoff, the virtual floor is yours.
Well, thank you so much, Steve. And when you mentioned rebuttal, I'm just glad that my wife is not tuning into this program, because after that very, very nice introduction, I'm sure she would demand rebuttal time. But I want to give first a little bit of an overview of how the regulation of corporations has developed in this country, and then suggest that it's kind of weird and maybe should be changed in significant respects. If you go back to the very beginning, historically, the regulation of companies in the United States was exclusively a matter of state law. In the case of corporations, the controlling laws were primarily those of the state of incorporation. And prior to the Civil War, most companies were incorporated in the state where they did most of their business. But with the rise of large national corporations in the late 19th century, states began competing as sites for incorporation, offering generous tax breaks and other financial advantages in return for increasing corporation fees and other benefits to the state. And in what in effect became a race to the bottom, the two competitors were Delaware and New Jersey. But the Delaware General Corporation Law, enacted in 1899, so reduced corporate taxes and shareholder interference with management that not even New Jersey could compete. And as a result, Delaware became and has remained the primary site of incorporation of most large US and a great many foreign corporations, including, for example, over 2/3 of all Fortune 500 companies. Despite occasional new competition from states like Nevada, Delaware's dominance as the preferred state of incorporation and corresponding primacy in the development of substantive corporate law has been further solidified by Delaware's constant attention to the needs and desires of corporate management. Delaware law offers, for example, considerable freedom from managerial liability for actions that can be characterized as an exercise of, quote, business judgment. It also offers protection from unwanted takeovers, anonymity of ownership, especially for offshore companies, and overall very light regulation. Perhaps most important from a legal liability standpoint, Delaware funnels most corporate disputes into Delaware's Court of Chancery, where, although the judges are very able, no jury trials are allowed. And if there's anything, in my experience, that a corporate executive fears, it's trial by jury. The law governing the everyday affairs of companies thus became, as it remains today, the law of the states, and in the case of large corporations, primarily the law of Delaware. During the Great Depression, however, the federal government, attributing much of the economic collapse to corporate dishonesty, decided to partially intervene in the form of the Securities Act of 1933 and the Securities Exchange Act of 1934, both administered by the newly created Securities and Exchange Commission. And the SEC quickly developed, I think, a well-earned reputation for being more independent of corporate management than Delaware or most other states were in practice. All of this was done pursuant to the Commerce Clause, but the basic division was between substantive corporate oversight and requirements, which was left largely to the states, and procedure, or more precisely disclosure, which was now shared with the states, but was at least in major part a federal function. And in that regard, I remember my very first day as a brand new associate at the Debevoise firm. And I was initially assigned to the corporate department, and a partner called me in and said, "Here, we've drafted this proxy statement and we know it complies with SEC requirements. Now go blue sky it." And I didn't have the nerve to say, "What the hell does that mean?" So I ran to a senior associate, not Steve Cass, who, by the way, was a senior associate there at the time, but another senior associate. And I said, "What the heck is a blue sky? And what am I supposed to do?" And in those pre-computer days, what it meant is taking out these huge volumes, CCH volumes of state law, and finding out whether the proxy that had been drafted with respect to the federal law also complied with the law of all the 50 states regarding their disclosure requirements. The one thing I learned from this experience was I'd rather be in the litigation department. But in any event, the point of all this is that substantive corporate law still was largely a function of state law, mostly Delaware law. Now, it is true that because of the federal securities laws that were now enacted, a failure to disclose or a disclosure that was dishonest could result in civil penalties, injunctive relief, and occasionally in criminal sanctions. But while these laws went a fair way toward creating a more honest marketplace in corporate securities, they were and they remain largely limited to mandating disclosure of information. Substantive regulation of how a company is structured, how it's managed, how it goes about its business remains to this day mostly a matter of state law, though there are a couple of exceptions that I'll mention later. And in the years immediately following World War II, this division seemed to be working pretty well. An increasing number of Americans now felt comfortable investing in securities, secure in the knowledge that what the company was reporting about its profitability and net worth was a lot more accurate than had been before the Depression. And as a result, by 1950, over 90% of the shares of publicly traded US companies were owned directly by individual investors. In other words, a growing number of everyday Americans had a stake in American business and a concomitant need to see that it was well managed. At the same time, as a consequence of progressive income tax policies and increased unionization, the percentage of US net wealth held by the richest 1% of Americans, mostly corporate executives, had by 1950 declined to less than 10%, a distribution that remained more or less constant for several decades. But in more recent decades, all of this has changed dramatically. Most corporate securities are now held by institutional investors, such as asset management funds, pension funds, mutual funds, hedge funds, and the like, which own, for example, more than 70% of the stock of Fortune 500 companies. The three biggest asset management funds, Vanguard, BlackRock, and State Street, themselves hold almost a quarter of the equity in the nation's largest corporations. Now, of course, many individual investors are invested in those funds, but that does not provide them with any immediate control over, or frankly, even much knowledge of what's going on at the underlying companies in which these funds invest. That might not be so bad if the funds themselves had an interest in how these underlying companies conduct their business over the long term. But with a few exceptions, notably at BlackRock, a great many such funds have little or no interest in corporate governance or behavior because they are only investing for short-term profits and will rapidly change their investments from one company to another as short-term financial trends dictate. For example, in the 1970s, when most New York Stock Exchange securities were still held by individual investors, the average length of time a share of an exchange company was held by an average investor was about 7 years. The average now in this era of institutional investors is about 7 months. Huge change. Indeed, according to some estimates, about 70% of all US securities trading is now done by hyper-speed traders who may own a given share for just a few seconds. Further still, much of this trading is accomplished by use of mathematical algorithms, and to that extent is dictated by source codes, which are focused on profitability. And even those funds that have longer-term investment strategy commonly outsource their shareholder voting rights to separate services, thus not really choosing to exercise their power over management. If the company doesn't deliver money, they switch to another stock, but that's about it. An equally significant change has been the shift from public to private financial markets, which are often free of most of the disclosure requirements of federal law. As SEC Commissioner Allison Herron-Lee stated in a speech last year, quote, "Perhaps the single most significant development in securities markets in the new millennium has been the explosive growth of private markets. More capital has been raised in these markets than in public markets for each year for over a decade. The increasing inflows into these markets have also significantly increased the overall portion of our equities markets in our economy that is non-transparent to investors, markets, policymakers, and the public," close quote. In other words, the federal regulation, which as mentioned is focus on disclosure, doesn't even play a role with respect to an increasing portion of the marketplace. Finally, the richest 1% of Americans, again, mostly corporate executives, hold as of June 2021, an astonishing 32.3% of US net wealth, much of it tied up in securities. While this may be chiefly due to reduced tax rates, the ability of lightly regulated companies to enhance their executives' wealth through various devices such as adjustable stock options clearly contributes to this very significantly changed distribution of wealth. And to be frank, I don't see much evidence that this is going to change in the immediate future. But given these developments, what I am going to suggest is that it may well be time to reevaluate the balance between state and federal regulation of corporations. And I should mention three small developments in this regard. After the accounting scandals of the late 1990s involving Enron and WorldCom and Tyco and the like, Congress passed in 2002 the Sarbanes-Oxley Act, which tightened up the standards for auditors as well as mandating several internal compliance standards and the like. Similarly, after the Great Recession of 2006, 7, and 8, Congress in 2010 passed the Dodd-Frank Act, which, among other things, increased the role of independent directors, most particularly with respect to executive compensation. And in a different kind of development more recently, mention should also be made of the so-called ESG movement, a private movement that seeks to encourage investors to compel companies to meet a set of progressive environmental, social, and governance standards. But overall, to be frank, none of these developments has been of major impact. The substantive corporate law is still largely a matter of Delaware law and other state law. And as I mentioned at the outset, when you think about the fact of we're now in a global economy and have been for several decades with huge multinational companies, it is a little bit strange that one small state should be dictating how corporations conduct their affairs. It's one thing for Delaware to give us a president, but it's quite something else for them to control how corporations operate. I personally think that greater federalization of corporate substantive law would be a welcome development. One obvious benefit would be greater consistency, but I also think it would lead to greater shareholder protection. And let me give an example involving insider trading and the concept of fiduciary duty. Well, most states hold that the managers of a company owe a fiduciary duty to their corporation, that is, a duty of honesty, loyalty, and care. States actually vary considerably on what that duty entails and to whom it applies. For example, as mentioned, Delaware and some other states often turn a blind eye on an executive's using his position to promote his self-interest, provided he is still exercising a reasonable, quote, business judgment on behalf of the corporation. And I feel quite confident that a federal definition of fiduciary duty would almost certainly be more exacting. And I say that not just abstractly, but with reference to a case I had way back in 2012, United States versus Whitman. This was an insider trading case, and as I'm sure many of you already know, insider trading is not specifically the subject of any federal statute, but was developed largely by the SEC and the courts through an extension of the notions of fraud to apply to certain breaches of fiduciary duty, the theory being that a fiduciary owes a duty to disclose to his company what he's doing, and if he fails to disclose it, then he's breaching his fiduciary duty, and that's a form of fraud. So in this particular case, which was a case of some low-level employees of a company that was incorporated in Delaware, but was doing business primarily in California and had its principal place of business in California. It turns out that the rules and this case law in California regarding the application of fiduciary duty to low-level employees is much less exacting than it is to high-level employees. And so the defense in the case, in part, was that, yes, we did leak some confidential material, confidential information to our friends, but that was not a breach of fiduciary duty under California law, and therefore there was no fraud. Well, in looking at this, it seemed to me that the application of federal fraud laws, even when involving breaches of fiduciary duty, could not and should not turn on the discrepancies between various state law definitions of fiduciary duty. And so I held, taking a good 19th century concept, federal common law, that under federal common law, there was a single definition of fiduciary duty applicable to these statutes. And to my utter surprise, I was affirmed by the Second Circuit. I should mention that Brad should get a chuckle out of that because he had me reversed in the Second Circuit in another case. But I've forgiven you, Brad, don't worry. But to get serious, what this example illustrates is how weird it would be if something as widespread and important as insider trading, even though a federal criminal violation, would vary depending on state law of fiduciary duty. And I give that just simply as an example of why I think federalization of much of this law is in order. In broader perspectives, this much seems apparent. The huge shifts in recent decades in corporate ownership, private markets, and income distribution have created regulatory challenges to achieving fairness and honesty in the conduct of the business in the United States and in the conduct of business in the United States. And the federal government has for too long relied on state legislatures and state courts to regulate how companies do business beyond matters of disclosures. And frankly, it's not an even match. The impact of corporate lobbying in a small state like Delaware is obviously much greater than on a national level, though it's not without power even on a national level. Speaking of that, consider also the fact that in this era of multinational companies, there are all sorts of laws that are now being passed by other countries that at least arguably would apply to any US-based multinational company, perhaps even in its conduct in the United States. And I'm thinking in particular of environmental regulations that have now been promulgated by countries like the Netherlands. It's one thing for the federal government of the United States to deal with those and to determine whether they should be enforced internally and whether negotiations should be made with the Netherlands or other countries regarding the scope of these regulations. But it's impossible to think of Delaware negotiating with the Netherlands over something like that. And for that matter, it's very unlikely that most states even know about these regulations. This is something that would be known, if at all, at the federal level. Now, unfortunately, most recent movements towards federalizing corporate law, modest though they be, have come after crises. And I certainly don't want another crisis to precipitate greater federalization of corporate law. But nevertheless, I think on the merits, there's a great deal to be said for the federalization of corporate law. So that concludes my remarks. I'm interested in hearing the response.
Thank you very, very much, Judge Rakoff. Let's turn now to Brad Karp. And Brad, how do you react to Judge Rakoff's suggestions? Do they make sense? How do they work for clients? What problems do they present? And what do you think about all this?
Sure. Thank you very much, Steve. It's never a good idea to follow Judge Rakoff in anything I've learned. The judge is one of my professional heroes and someone who I hold in the highest imaginable regard. I must confess, not surprisingly, that I agree with virtually all of the judge's observations, but I do want to offer a number of observations from my perch as a longtime defense lawyer, someone who has spent close to 40 years representing Fortune 100 companies, defend against existential civil, regulatory, and criminal threats. I guess my first foundational principle is that most corporations care far less whether the source of law is state or federal, or whether the enforcement authorities are state or federal, and they care far more about clarity, certainty, predictability, and fairness in application. To the extent that federal regulation can provide those outcomes, businesses may well find federal regulation and federal legislation more desirable than state regulation and legislation. Even though state legislators and state regulators tend to be more prone to capture by the bar and by lobbyists. This principle is particularly true for national and multinational corporations that operate across multiple jurisdictions on a daily basis. Such entities typically engage with federal regulators, such as the SEC, on a more regular basis than with state regulators. The knowledge and the relationships that come with being a repeat player can increase clarity and predictability for the company. Indeed, there are many examples in which corporations have expressly promoted federal regulation over state regulation. For example, it was corporate interests that supported the Securities Litigation Uniform Standards Act of 1998, SLUSA, which sought to centralize securities litigation in federal courts by expressly preempting state securities law. I want to spend a couple of moments talking about problems arising from duplication, which is a significant issue. One of the biggest regulatory concerns for businesses and a profound frustration for defense lawyers results from being subject to multiple and overlapping regulatory regimes for the same basic underlying conduct. The problem here is federal and state law, not federal or state law. If the program topic were different, I would also add foreign law and the intervention of foreign regulators and foreign enforcement regimes. As Judge Rakoff noted, Congress has broad power to regulate commercial conduct. At the same time, under settled precedent, courts presume that Congress does not intend to preempt state law when enacting a federal statute. State law consequently may operate in the same field as federal law, so long as the state law does not expressly conflict with the federal rule. For that reason, the enactment of federal law often adds an additional layer of regulation on business without displacing state regulation. The reality, the practical reality, therefore, is that state and federal regulatory authorities frequently coexist and compete with each other for cases. Sometimes they work together on cases, and too often they work separately on cases and do not cooperate with each other. That can result, and it very frequently does result, in corporations not only having to pay different federal and state regulators and government agencies for violations arising out of essentially the same conduct, but also requiring the corporation to deal with and respond to multiple time-consuming and expensive investigations arising out of the same conduct. And the problem extends beyond cross-currents between state and federal regulators. All too often, multiple federal regulators and multiple federal enforcement officials attempt to investigate and regulate the same conduct. There are lots and lots of examples in which this occurred. Some recent ones. In 2018, Societe Generale paid a total of $1.3 billion to 5 different federal and state regulators and agencies to resolve what were essentially overlapping sanctions investigations. Payments were made to OFAC, the Southern District of New York, the Manhattan DA's office, the Federal Reserve, and the New York State Department of Financial Services. In 2019, UniCredit paid $1.4 billion to the same 5 regulators and agencies in connection with overlapping sanctions investigations. In 2019, I represented Standard Chartered, which paid $1.1 billion to the same 5 regulators, plus Britain's Financial Crimes Authority in connection with overlapping sanctions investigations. And of course, the largest sanctions case in history was BNP Paribas' 2014 $9 billion settlement paid to multiple overlapping federal and state regulators and criminal enforcement authorities. I routinely today see businesses being subject to antitrust investigations by the federal DOJ, as well as AGs in multiple states, all for the same basic corporate policy developed at the corporate headquarters and implemented nationwide. These overlapping areas of investigative activity are not only frustratingly expensive, but they can also give rise to difficult practical questions for clients and employees. For example, does a key employee take the Fifth Amendment in testimony before a state regulator, which invocation can later be used against the company and the employee in a federal regulatory proceeding or a federal related civil litigation because of the pendency of the related criminal matter? In practice, defense counsel will try his or her best to mitigate the harm that can arise from competing investigations and look for ways to use it to their client's advantage. For example, defense counsel may or may not, depending on the circumstances, try to consolidate investigative activity so as to alleviate the burden on their client of responding to different investigative requests from different regulators and agencies. Practitioners also often try to play one agency off of the other in settlement negotiations. Separately, it's worth noting that federal law generally acts only as a floor for regulation in a particular area. In other words, states and even local governments may enact more stringent regulations than federal law requires, unless federal law expressly precludes that outcome. The result is that even if federal regulators are able to strike an appropriate and thoughtful rule to regulate businesses acting on a national and international basis, state regulators can enact more stringent regulations that differ in their requirements, so long as those requirements do not fall beneath the federal flaw. That imposes enormous costs on large companies operating in multiple jurisdictions. It also typically results in a type of race to the top. Businesses may default to complying with the most stringent form of regulation imposed by any state for all of their activities nationwide if it would be impractical or impossible to adopt different standards of conduct for different jurisdictions. Such outcomes effectively interfere with the sovereignty of other states that have decided to tip the balance in a less regulatory manner. Of course, Congress can avoid these problems by enacting an express provision preempting all state regulation in a particular area, but as a practical matter, Congress rarely does that. In Dodd-Frank, for example, which Judge Rakoff mentioned, Congress preempted state consumer financial laws, but only to the extent that state law discriminates against national banks, significantly interferes with the national bank's exercise of its powers, or is expressly preempted by a separate provision of federal law. As I mentioned before, SLUSA is a counterexample, but even there, the Supreme Court interpreted the provision narrowly to allow for 1933 Act securities suits to be brought in state court and be removable only in limited circumstances. And we've seen the havoc that has created because of the Supreme Court's ruling in Cyan. As a result, in the absence of express preemption, many businesses are likely to resist an additional level of regulation from the federal government. Let me turn now to judicial control of hyper enforcement. Judge Rakoff recognizes, and in his writings and in his rulings, has recognized the tendency of federal regulators and federal prosecutors to push the boundaries of their authority. This too, in my view, is not a federal versus state issue. It is a federal and a state issue. State regulators have the same tendencies, and the problems, in my view at least, are often more punitive on the state level than on the federal level, because state courts are often part of the same political ecosystem, and state court judicial review tends to be less exacting and less rigorous, allowing for more aggressive state regulatory enforcement, which often goes effectively unchecked. On the federal level, courts have been much more willing to rein in aggressive theories of prosecution. Since 2010, the Supreme Court has issued a number of decisions rejecting aggressive theories of prosecution under various federal criminal statutes. In some of the cases, the court has specifically rejected interpretations of the criminal law that would result in a sweeping expansion of federal criminal jurisdiction. In fact, just last week, the Supreme Court issued 2 decisions rejecting criminal prosecutions on exactly such grounds, and the First Circuit issued a 3rd decision. In Simonelli versus the United States, the Supreme Court last week unanimously rejected the right to control theory of liability under the federal wire fraud statute, which the Second Circuit had endorsed for more than 30 years. Under that theory, a defendant would be guilty of wire fraud if he schemes to deprive the victim of potentially valuable economic information necessary to make discretionary economic decisions. The court held that the right to control theory was inconsistent with the statutory text and structure, and that it improperly expanded federal jurisdiction without express statutory authorization. In Percoco versus the United States, the Supreme Court last week rejected a broad theory of honest services fraud, pursuant to which prosecutors could charge anyone with significant influence over government decisions, including particularly well-connected and effective lobbyists. Separately, last week, the First Circuit threw out convictions for honest services fraud in the Varsity Blues college admission scandals, relying on the same line of cases. So 3 basic principles of due process underlie many of these decisions. First, a penal statute must define criminal conduct with sufficient specificity such that an ordinary person would understand what conduct the statute prohibits. Second, an interpretation of a criminal statute that sweeps in a significant amount of routine conduct is inherently suspect, in part because it would allow for arbitrary prosecutions. And third, criminal liability in the absence of a guilty mental state is rare and disfavored. To the extent that federal and state prosecutors continue to push the envelope by adopting sweeping interpretations of broad criminal statutes, this intervention by the courts is welcome on both the federal and on the state levels. Let me spend a moment or two on some potential solutions. Creating clear lines of authority. In my view, it would be enormously helpful if there were more robust and express preemption when the federal government chooses to act, and a clear delegation of federal authority to specific agencies to avoid the multiplicity and overlapping regulation and enforcement issue. It would also be helpful, in my view, if there were more effective policing of efforts of state regulators that seek to exercise authority beyond their borders. greater accountability for federal regulators. Capture is a pejorative term for democracy. Corporations are seeing now at the FTC, DOJ Antitrust Division, and to a lesser extent at the SEC, what regulators that are well insulated from the democratic process and enlightened with untested theories can do with their broad authority. We've seen heads of federal enforcement authorities, particularly recently in the antitrust arena, publicly announce that they are not bound by precedent, but that they instead seek to create an enforcement regime based on what they would like personally to see the law be. This creates profound uncertainty in the corporate arena, and in my view, has damaged and destabilized our nation's economy. Accountability is important. So are predictability, and so is adherence to precedent and adherence to the rule of law. Multiple business viewpoints. Large multi-state, multinational incumbent businesses might well favor the certainty of uniform federal regulations, even where compliance might be more costly. Smaller upstart companies, on the other hand, see little benefit in the certainty of regulations that impose excessive compliance costs. Supervision by the courts. Courts, in my view, should continue to send the message to prosecutors at both the state and the federal level that they cannot leverage ambiguity in federal and state criminal statutes into a sweeping power to prosecute routine swaths, huge swaths of routine conduct. Let me turn to the issue of ESG, which is where a number of these currents collide. A stark federalism issue that corporations are facing each and every day involves ESG and the very real risk of corporations being caught in the middle of political controversies that are amplified by the new federal ESG mandates. For example, the SEC has recently proposed a rule requiring regulated business to disclose certain climate-related information, including greenhouse gas emissions. Federal law now requires even more significant climate-related disclosures of federal suppliers and federal contractors. The SEC is also proposing additional disclosure requirements concerning investment firms' consideration of ESG factors. Separately, the Department of Labor recently promulgated a rule allowing retirement funds to consider ESG factors when making investment decisions. As the marketplace and as the investment community have been pushing corporations to prioritize ESG initiatives, and as the federal government is now requiring the disclosure of those initiatives or risk enforcement penalties, there has been significant pushback from conservative state governments. Attorneys general from nearly 24 red anti-woke states are opposing both of the SEC's proposals. A group of red state anti-woke states have filed suit in federal court challenging the Department of Labor rule. States, including Texas, have enacted laws limiting access to state contracts and pension investments for Fortune 50 companies that have compliant ESG policies. Conservative state and conservative federal politicians are using the SEC and Department of Labor initiatives as an opening to publicly attack businesses with compliant ESG policies as being too woke and as prioritizing what the politicians view as liberal political values over the interests of their stakeholders. So corporations find themselves in a true no-win situation. Because of movements by the federal government and pressures from the marketplace, businesses are required to develop and publicize their ESG-related policies, but they are then punished by state politicians who disapprove of those very same ESG initiatives. The criticisms are not limited to a general attack on corporate America. Specific companies are being targeted. BlackRock, for example, received letters from Senator Tom Cotton and 19 Republican attorneys general asserting that BlackRock's involvement in a climate-related ESG initiative may violate federal and state law. The Kentucky Attorney General is investigating Vanguard's and State Street's ESG practices for potential violations of state consumer protection law. Oklahoma has banned BlackRock and JP Morgan, as well as Bank of America, Wells Fargo, and State Street from doing business with the state. Corporations have become a pawn in an ongoing political battle, and at least right now, there is no effective way out. In this circumstance, less regulation is probably better, allowing businesses to consider ESG as the market dictates without either the federal or the state government interfering with those natural market forces. There is always the question of whether the federal government has the power to preempt state law in this area, but that power realistically doesn't extend very far. The federal government likely has the power, as Judge Rakoff mentioned, to preempt state laws that forbid entities doing business in interstate commerce from considering ESG or investing in companies that do consider ESG. But there is a substantial question of political will. Would Congress really be willing and able to push through such legislation? I, for one, am skeptical. It's also worth considering how many broad areas are now subsumed under the ESG umbrella. Congress realistically is not going to forbid states from legislating on the sorts of issues that corporations are considering every day. And even if Congress could act, states are always going to be free to do business with the companies they wish to do business with. For example, the federal government cannot displace the state legislature of Oklahoma and direct the state to do business with companies that consider ESG. Given the limited ability, in my view, of the federal government to control the ESG space, it may well be best for Congress not to engage directly on these issues. While the federal government's disclosure regimes may be well-meaning, they're only fanning the flames and exacerbating an already fraught situation. This, after all, is a situation where the market is driving consideration of ESG issues, and there is no clear market failure at present that requires the urgent intervention of the federal government. And state governments have occupied the ESG space quite purposefully and aggressively, and I might editorialize, quite cynically. So-called anti-ESG legislation recently passed by several states has the effect of constraining and not enhancing business and competition within those states. The anti-ESG legislation is motivated by a broad host of social, normative, political, and other issues. That said, I cannot see the federal government successfully displacing or even trying to displace the role of state legislators in framing ESG legislative policy, no matter what the state legislators' political motivations might be. And with that, I conclude my remarks.
Thank you very, very much, Brad, for those very thoughtful remarks. And they lead directly into what I think will be Professor Posner's comments. Mike, how will the ESG movement and more broadly corporate attention to environmental and social and governance issues survive in the context of the maelstrom that Brad has described?
I was going to talk about that later on, but let me take it on first. And Brad, I agree with a lot of your assessment of some of the chaos and confusion that's going on, but I have a somewhat different view of where we are and where we ought to go. ESG didn't fall from the skies. It hasn't been part of our landscape forever. It's barely 20 years old. And it was started quite modestly by some banks, by the Swiss government, by the UN, with the thought that there ought to be some consideration of environmental, social issues somewhere in the marketplace, but very modestly. And I think it's still actually being applied very modestly. And so Judge Rakoff talked about BlackRock and State Street and Vanguard. They control, what, $20 trillion. They all have big ESG funds. It's quite clear to me, looking at what they're actually doing, that their ESG funds, and most of them that are out there, I would say almost all of them, are really looking at risks to investors rather than focusing on risk to people and the planet. They talk about those things. The marketing is spectacular, but Larry Fink is not a woke capitalist. He's just an old-fashioned capitalist. And he's going to make sure that his ESG funds match the market. He's going to make sure that he is essentially delivering returns for his investors. And that's true across the board. I think quite cynically, the Governor DeSantis and others have capitalized on this rhetoric. The rhetoric is way ahead of what's actually going on. They've done that in part because they don't believe in climate. There's a problem with climate change. They don't want diversity. This is a political issue, not a legal issue. And I think it's a mistake for us to get too wound up about this. I agree with you. I don't think the federal government ought to get involved. I do think we need to distinguish between public fiduciaries, state pension funds, for example, where Governor DeSantis or Abbott are right in saying, if they're protecting the retirement accounts for teachers and firefighters, those people are absolutely entitled to get the best return on their investment. But I think we need to de-link that from the massive wealth in our society, people who have family offices, who have individual wealth, maybe universities, foundations, people who have discretionary investment income and who might be willing actually to invest in an ESG fund that was actually evaluating risk to the planet or to people, understanding that they may not get the same return on investment. People buy electric cars. People buy solar panels to put on their rooftops. People make choices all the time that reflect their values. And I think the faster we de-link the public funds, where there is a fiduciary duty, from discretionary investors, women, millennials, who actually are driving a lot of this motivation for firms to set up ESG funds. I think we ought to set up what I call ESG Prime or ESG Plus, where those that are inclined basically say, we're going to do this because it's consistent with our values, and for us, getting the maximized return in the next quarter is simply not as important. Let me leave that to one side. I want to just say a couple of things. The subject of this night is new frontiers, and I want to blow the discussion open a little bit and say, we're not just talking about the federal system versus the states. We now live in a globalized world where, in fact, a lot of the things we're talking about may be overtaken by events because other states, especially in Western Europe, have a much more aggressive view about some of these things, and they're beginning to act on it. We need rules of, I agree also with something that Brad said about, trying to avoid duplication. We need rules of the road for a globalized economy where you have weak states and giant global companies, and you have basically a governance gap. And so whether it's with regard to supply chains where, 40, 50 years ago, we had all kinds of protections for workers in the United States. Now manufacturing for many industries is overwhelmingly done someplace else. And it's someplace where labor costs are cheaper, regulations are weaker, and workers are not being protected. We have a whole range of issues with critical minerals. We need polysilicon for the solar panels. It's coming from Xinjiang province in China. We need cobalt for electric cars. It's coming from the DRC, from the Congo, 20% of it, from artisanal mines where there are 25,000 kids. And so I would just say, adding to the confusion of this discussion or making it even more overwhelming, I think we need to be looking at how we as a society, as a legal community, deal with the fact that these issues now extend beyond our borders. American and global companies are operating with a new set of rules, and we need to be part of the discussion of what those rules should be. Last point from me, and I'll stop. We've made a few efforts. I think Brad mentioned and Judge Rakoff, the climate disclosure coming out of the SEC, which was opposed by industry, more industry opposition to scope 3 emission disclosure than any proposed rule since 1934. We have a law now called the Uyghur Forced Labor Prevention Act, which says you can't bring in solar panels if the silicon's coming from China, from Xinjiang. And we have, in another kind of odd way, the states taking the lead in regulating content on the internet. You have 2 cases called Net Choice versus Paxson and Moody, one from Florida, one from Texas. The 11th Circuit and the 5th Circuit have gone the other way. 2 states basically telling social media companies, you cannot take down things that we think ought to be on your social media sites because we think you're also woke capitalists and you're trying to take down conservative content. That's going to wind up in the Supreme Court this year. But more importantly, last for me, we need to see what's happening in Europe. The European population, the European public has said, whatever has happened in the last 15, 20 years with the UN trying to kind of create some global rules, it's not working. And they've one after another started to take on these issues. The French passed a due diligence law in 2017, the first one. Now the EU this year is going to mandate that all 27 European Union states pass mandatory due diligence, details to be determined, but it's certainly going to affect American companies because any company in France, for example, with 3,000 employees in France is subject to that French due diligence law. Germany this year passed a supply chain law, which says that any company with 1,000 employees working in Germany is subject to their supply chain law. That's 400 of the 500 Fortune 500 companies. And there are laws now on tech, the Digital Services Act, the Digital Markets Act. We've seen it in the privacy space where GDPR, the Global Data Protection Regulation, has become a global standard for privacy. I predict it's not going to happen overnight, but I predict that the Europeans are going to push harder and harder on these things. They're going to develop rules. They're going to develop standards. They're going to require reporting. And I think our conversations about whether it's the states or the federal government in some ways are going to be superseded by the notion that others are taking the ball and taking a more aggressive approach to some of these issues than we've been willing to do. Let me stop with that.
Thank you, Michael. Very thoughtful and interesting comments. Judge Rakoff, you were promised rebuttal time, and this is an opportunity for you to comment on anything you've heard from either Brad or Michael.
Well, I'll just be brief because I agreed with a great deal of what both Brad and Michael said, and I don't view this really as a rebuttal, but to put this again in broader context. So the classic defense of federalism, if you will, was Louis Brandeis's assertion that it promotes experimentation, and that in a country as diverse as ours, we can all benefit from having various experiments tried out in one state or another. I think history has not been particularly kind to that point of view. And I really strongly agree with Brad that from a businessman's standpoint, predictability is critical. And I would even go a step further and say the law generally, predictability is one of the essential components of any country that calls itself governed by a rule of law. So that if there are changes, yes, they're made across the board by a legislature or Congress, but not by this sort of quilt pattern approach that we now face that Brad mentioned. Now, of course, there are always motives involved in corporations pressing for consistency in certain areas and perhaps not in other areas. I'd be interested if Brad or Michael knows. I haven't seen an across the board movement by large American corporations to seek to more greatly federalize corporate law, even though from what Brad said, they ought to be pushing for that, and maybe I'm just not familiar with it. Where they have pushed for it, there are often special motives involved. Solution was an example. So what was going on there was that private securities lawyers were bringing great big security actions in forums, state forums, where they knew the jury would give them big awards. I totally agree that that was a bad thing, that Congress was right to act, but that was the immediate reason that the securities industry sought that legislation, was to prevent a form of forum shopping, if you will. With respect to the expansion of the mail fraud and wire fraud statutes by prosecutors, both state and federal, that was largely prompted by the failure of, particularly on the local level, of local prosecutors to police corruption in their governments, because the prosecutors were part of the same machine as the corrupt legislators. I think the Supreme Court was exactly right in its reading of the mail fraud, wire fraud statutes, not just in the recent cases, but going back to a case called McNally. But what prompted the lower courts and what prompted the prosecutors to move forward is they felt that local corruption was not being prosecuted by local prosecutors, and therefore they wanted to step in. The right people to step in my view, would have been Congress, and to pass a law governing state and local corruption, which I think they constitutionally could do. But of course, that would be an exercise of political will that Congress perhaps not easily undertakes. My broad point is that I think whatever merits there may be to local experimentation, in practice, they have more often been reflections of local biases, and whether they're good or bad, they create for the American business community an unpredictability that is very unfortunate, and is most unfortunate, of course, in the area that Michael was referring to, which is international regulation, because, as I mentioned before, I just don't see Delaware negotiating with the EU. Those are my thoughts.
Thank you, Judge Rakoff. Brad, I wonder whether you have any comments on Professor Posner's remarks about what's happening in the EU, how they, in his view, the developments there will inevitably apply increasingly to U.S. corporations, and how that bears on the patchwork quilt of fiduciary obligations and other sort of corporate conduct issues that we now have at the state level.
Sure. I agree with Mike that what's happening in Europe is some of it has arrived at our shores. Much of it inevitably is going to arrive at our shores, and first of all, many global corporations have already needed to adapt to the very rigorous wave of regulation, ESG related and other regulation that the EU and other bodies throughout Europe have imposed. So they're already in the process of gearing up for much greater regulation. It's complicated because when you deal with different jurisdictions that impose different levels of regulation, it's generally easier, though it's more expensive, for corporations to be prepared to comply with the greatest, most punitive, most intrusive, most onerous regulations, because it is very difficult to have different styles of compliance with different types of regulation across multiple jurisdictions. So that's already happening. With respect to domestic corporations, United States domestic corporations, they are very much prepared to ratchet up their compliance to meet what is going to come over the next year or two or three. And it's a very complicated process. To some degree, the most mature corporations are much better equipped to make the expenditures to meet the regulatory burdens. So there's going to be an incumbency bias that large incumbent public companies that have significant resources on hand are going to be much better equipped to comply with the new wave of regulations, making it much more difficult for smaller, newer, upstart corporations to compete effectively. You know, there's an argument that that's going to, in the end, stifle innovation because smaller, younger, more immature corporations aren't going to be able to cope with the wave of intrusive regulations that are coming. But again, the main issue is you're now seeing the SEC get very actively involved. Gary Gensler is following very closely what's been going on in the EU and across Europe, and has been ratcheting up the level of regulation that American companies are now having to cope with. And you now have a whole wave of states, conservative, anti-woke, red states, that are lying in wait, waiting to tell any corporation that's going to comply with what the SEC imposes or what the EU has imposed, you do that in our state, you're not going to be able to participate in underwritings. We're not going to do business with you. And it's putting corporations in our country at an incredible disadvantage and making competition and innovation and the ability to operate seamlessly across the federal United States virtually impossible. I mean, the whole recent issue with DeSantis and Disney and legislation that is clearly targeted to punish a company because of policies that it put in place is just an example of raw political power being exercised against a company, against a corporation to settle a score for political advantage. That really isn't how our system is supposed to work.
And if I may, what can be done about that, given the paralysis in Congress, given the clear global perspective that you've articulated and that Mike and Judge Rakoff have also articulated, if it's not shared at the state level where decisions are being made with respect to corporate conduct?
I'm happy to take the first crack at it. You know, one is an unsatisfying, slow process, which is you vote them out of office. But that's not going to happen. I mean, you have state legislators that are controlled by political parties, and we're not going to see change over the next decade. So even though the citizens of those states are being harmed because capital costs are increasing artificially, because there's not competition among all participants, because a whole segment of financial institutions are being cast aside because they have complied with ESG policies. So the state citizens are paying more higher capital costs, the taxes are higher, and there's less competition. That's an incredibly unsatisfying, unfair burden that is being borne to settle political scores. Voting them out is one answer. But beyond that, you're seeing judicial challenges, but those have thus far all failed. I'm hoping you'll see more judicial challenges in federal court that can wend their way up through the appellate process, where hopefully you'll get an impartial shot and there'll be a meaningful, rigorous review. But I don't hold my breath.
Judge Rakoff, do you have any thoughts on that last option?
Well, I would certainly hope those cases would be assigned to me. I'm tired of doing these Social Security cases. As the fundamental problem, which I think we can't escape, is how powerless Congress has become because of stalemates and divisions and whatever. That is the natural body to deal with these problems, but they can't, or they have found themselves incapable of compromises except under the most extreme situation. So I don't have a quick answer, but I do think that's the heart of the problem.
Michael, do you have not a quick, but at least a slow answer as to how we're going to educate state and federal legislators and perhaps even judges to make progress on this issue?
I'm not sure about educating them, but I would say I think for corporate leaders, there ought to be a distinction between things that are fundamental to how the companies are run and things where people as corporate leaders may have opinions about political issues in our society. I would be much more, inclined. Some of this is going to be inevitably a conflict. If a company decides that it has a value, it thinks there's a value in promoting diversity, it's part of this discussion. And Governor DeSantis doesn't want that. He doesn't believe in it. And so to some extent, we're stuck. We have to, I would say, hold your nerve. But I do think I have some anxiety when every political issue on the national stage becomes something that companies feel they have to speak out on. I'm actually quite conservative on that. I think you have to be focused on your business. The one area that underlies all of this, of course, is the efforts to disrupt our political system, stop the steal, voting rights, all of those things, I think go so fundamentally to the well-being of our democracy. I don't think companies can avoid being part of those discussions. And again, it will engender all kinds of blowback from the people that Brad's talking about.
Brad, perhaps to finish our conversation, you were prominent among the business and law firm leaders 2 years ago who did speak out with respect to threats to the democratic institutions of our society, particularly the right to vote. What is your view on the degree to which corporations can and should speak out on that issue, whether they're in red states, blue states, or otherwise?
Yeah, I generally agree with Mike's approach. Look, Paul Weiss, at least today, is a private company. We don't have shareholders, and we have a little bit more freedom and flexibility. Although, if we have this discussion in 5 years, I would expect some law firms are going to be public companies, and that'll be a different New York City Bar Association forum and debate. I think there's some issues that are so fundamental to our democracy that corporations have to speak out. I think the list is relatively small. I think what happened in terms of the post-2020 electoral results and the failure to peacefully transfer power and the voting discrepancies and the January 6th seditious assault on Congress, corporations have to speak out, and you are conspicuous in your silence if you do not. And I do think there ought to be a consequence if a corporation is unwilling to take a position on a core democratic issue as to which there really cannot be much debate. It's a slippery slope, because when you get into voting rights issues and you go state by state, you saw what happened when various corporations in Georgia tried to speak out on, disenfranchising voters, and Coca-Cola gets barred. Major League Baseball pulls the All-Star game out of Georgia. Things become very political. You go further down the slope and you get into areas of abortion rights, reproductive choice. There are certain third rail issues where you might think that you are supporting the rule of law and feel an obligation to make a statement because the Supreme Court, a legislative body, somebody has violated the rule of law. But you get into a political morass, and if you're a public company, you have a fiduciary duty to your shareholders, and you don't want to take positions. You've seen what happened, obviously, with Anheuser-Busch and Bud Light. I mean, you're losing billions of dollars of shareholder value by wading into certain issues of social justice. And I may believe 100% that they're on the right side of the issue. And 80%, 90% of Americans may believe that they're on the right side of the issue. But to inject a public corporation into a potentially divisive political issue is not in the best interest of the corporation. It'll be interesting when those issues get teed up before the Delaware courts, and you get into, the business judgment rule and how much directors are going to be protected when they stake out various positions. There are a whole range of novel legal issues that are yet to be adjudicated, but will be adjudicated in the not too distant future.
Thank you. And I think with that, Judge Rakoff, these comments bring us right back to where you started, I think, the conversation in terms of the wisdom of having at least some federal guidelines to address these issues, rather than requiring our corporations to go through the patchwork quilt as they struggle through these issues. Well,
I don't think we should ever forget what a great asset to our country has been the fact that our corporate markets and our corporations as a whole are considered far more honest than those of many other countries. And that's the reason why people invest in the American companies and why the companies can exercise the kind of influence they do. And to lose that would be, I think, a terrible mistake. My only quibble with what Brad said is, I always thought that Paul Weiss was a benevolent autocracy, but I guess I'm misinformed.
It depends on the day of the week, I suppose.
you are speaking to the chair, and if there's an autocrat, he would never be that. Listen, gentlemen, thank you all. This has been an extraordinary discussion. The issues are real and they're ongoing. And thank you so much for bringing your wisdom and your concerns to this discussion. Marcy, it is now time for me to turn the podium back to you after thanking Judge Rakoff, Brad Karp, and Michael Posner for their thoughts and their time this evening.
Thank you, Steve. On behalf of the Rule of Law Task Force and our co-sponsors, I want to thank Judge Rakoff, Brad Karp, and Professor Posner for sharing your illuminating insights and getting us really thinking about these very hard and challenging and uncertain issues. And I'm sure we'll be thinking about them increasingly in the years to come. I want to thank also the members of our audience who have chosen to spend part of their evening with us. This program has been recorded and it will soon be available on the nycbar.org website on the Rule of Law Task Force page. Thank you again to our wonderful panelists and to you, Steve Cass, and everyone. Have a good night. Thank you.